welcome to Season 6, Episode 12 of Fire Away, Rudner Law's online show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator, founder of Rudner Law, and your host for this episode of Fire Away. As a reminder, Fire Away streams live online every month, and if you miss an episode or want to watch one again, they're always available on our YouTube channel, our Facebook page, and our website. I am very excited about today's episode. I'm also excited to be back. It's been a few months since I've been in the host chair, but very excited about today's episode. I'm joined by Colm Brannigan. Colm is a very well-known ADR practitioner who provides mediation, med-arb, and arbitration services in a variety of types of disputes in Ontario. He also leads courses on litigation and ADR topics. Today, we're going to be focusing on how mediation, arbitration, and med-arb can be used effectively to resolve employment law disputes. So we're going to dive right into this. Colm, welcome to the show, and thank you so much for joining me.
Thank you very much, Stuart. I appreciate the opportunity to chat with you about topics that I'm really interested in, as I know you are as well.
Yeah, I definitely am. I've been practicing law now for over a quarter of a century. And for that entire time, people have been complaining about our court system and how inefficient it is and all the other challenges and problems we can get into. And at the same time, talking about ADR, alternative dispute resolution, and how that can be a much better way to address the disputes that we are dealing with. And yet, it's still, I would say, a minority of cases that actually take advantage of ADR, and many of those are where it's court mandated. So, really excited to talk about the what in terms of what ADR is, but more importantly, the how to use it efficiently and effectively. And with your background and your knowledge, I think I'm very excited to have you. So, why don't we start? I'll throw you the softball question of tell me a bit about yourself and your background, and then we can get into what is mediation and go from there.
Sure, thanks. Yeah, I mean, I practiced law and litigation for about 15 years and have been doing full-time ADR work for 24, 25. There was some overlap. And the main thing that was obvious to me was that although people are litigation or trial lawyers, they rarely go to trial. And there must be a better way to deal with it. And that's where ADR comes in, alternative dispute resolution, or from my perspective, the appropriate dispute resolution. What's appropriate to the dispute? What kind of mechanism, what kind of process? And so that's what really propelled me towards it. And I have a very mixed kind of practice, as you said, primarily coming from a mediation perspective, but I do arbitration. And I do a lot of med-arb, which is the hybrid process involving elements of both mediation and arbitration. I've designed courses for various colleges. I've taught at Queen's Law School, and I do a wee bit of training in online dispute resolution, which is one of my real interests, and in med-arb. So I've kind of a mixed bag. I'm not smart enough to only do one area of law. So I blunder around in a whole bunch of things as a mediator, which if I was doing as a lawyer would be really dangerous.
But I usually say I'm not smart enough to do more than one area of law. So I guess a different perspective. I like the appropriate dispute resolution for ADR. I've actually started saying advanced dispute resolution is what ADR should really stand for. But either way, I think we're coming at this from the same perspective that it beats the default, which is the court system.
And it more than beats it. Really, the court system is the alternative. If only a couple of percent of cases started in court get to a trial, you're spending all this time and money in a linear process that's going nowhere for most cases. And so I think the idea of mediation, arbitration, other processes as alternatives is actually wrong. It's the other way around. It's the court that's the alternative, at least at the trial level anyway.
Oh, absolutely. And look, I was always told that, the statistics showed, at least in Ontario, and I think it's pretty consistent throughout the country, that less than 2% of claims that are filed in court actually get to trial. And that's what I've been told for decades. I think if you look at it now, particularly post-pandemic, it's got to be even less cases that are getting through to trial. So many of them are resolved through simple negotiation between counsel. But there are quite a few that need to have some sort of intervention. I guess that's probably as good a segue as any into if you can summarize at least the Reader's Digest version for those viewers who don't know what exactly is mediation.
Well, mediation, first of all, it's not really a legal process, although it takes part, often takes place within legal disputes. It's essentially a facilitated negotiation where the mediator plays the role of the neutral, or, as I prefer to say, impartial kind of guide or process manager. What's important about it is generally voluntary, and that the parties control the outcome. The mediator can't tell them what to do, and they can end it at any time they want. So it's really a continuation of a negotiation kind of process, bringing in a third party to help when, for whatever reason, parties themselves or parties in counsel have not been able to bridge the gap between them. And it's a relatively simple sounding process that can be very simple, can be very complex, but can come up with good results. And I think bringing in the neutral or impartial person just helps change the dynamics. And that's how I would see mediation. The essence of it being also the confidentiality aspect.
Yeah, which is critical, and I think that that's a really helpful overview. And then, in the last few years, I've been spending a fair bit of my practicing time as a neutral mediator as well as arbitrator as well. So I've now seen it from all different perspectives. And one of the things that you and I talked about briefly before we went on air is the fact that people are not really using mediation as strategically or as effectively as they could. And one of your points was that people just, if they are going to mediate, they just follow the default mediation approach as opposed to customizing it. So, was hoping you might comment a bit more on that because that's another benefit of mediation is the flexibility.
Yeah, certainly the flexibility. And now, particularly when we're doing things online, we can have hybrid approach. We can do all kinds of different things just on the process. Um, so I think there's a fundamental difference between mediation as ticking the box to show you did mediation, and mediation as in taking it seriously as probably um, your best opportunity to resolve the dispute without somebody resolving it for you. And most people, I think, if given the option, would choose to resolve their own dispute rather than have a third party that they don't know, a judge or an arbitrator or whatever, do it for them. So it has this amazing ability to help people sort out their own problems in a way that litigation doesn't, because once you go into court or even to arbitration, you're no longer the most important person. The disputant isn't the most important person. You move from mediation, where it's up to you, to another process where somebody else gets to tell you what to do. So to me, mediation should be considered for virtually every case. That doesn't mean it should be used in every case, but it should be looked at as, can this get my client what my client needs? And it's not about process. And we tend to, I think, fall into a rut. I mean, in that we do what we're used to doing. And indeed, with the online dispute resolution, I mean, one of the reasons pre-COVID that people didn't do it was, well, why should I? There's no real reason to do it. And same thing happens.
Yeah, no, it's easy, and I have been very critical of counsel for not being strategic when it comes to mediation, not preparing, and yet I fall into the same habits. I've had a few mediations lately where I've been on as counsel, and it's easy to default into using the same template for your mediation brief and coming at it the same way. Um, Now, bearing in mind that the majority of our viewers are not lawyers, so they may be parties to mediation, and maybe frequent flyers, or it may be that they're going to have one time where they get to mediate. But what would you say to them in terms of if a mediation is going to be scheduled in your case, what should you be talking about with your lawyer, or how can you ensure that you're approaching it as efficiently, or that's not the right word, I guess as strategically as possible?
Well, often efficiency is strategic. It's how you do it, right? What you should be doing is making sure that you understand what mediation is in the particular dispute that you're involved with. And that means sitting down with your lawyer and going through what you can expect in the mediation. Now, there's always blips, there's always differences, but also in preparing. And in preparing, realizing you're probably going to have to compromise to some degree to come up with a solution. And compromise, it's not a dirty word, it's realism. Do you really want to fight over a principle that is going to cost you lots of money and really just take time, effort, and away from what could be a reasonable settlement? I think it's also incredibly important in the preparation that you understand what your alternatives are. Going back to the old getting to yes, BATNA, the best alternative to negotiated agreement than those. It also, I think it's incumbent on counsel to bring their client, and if they don't, the client to ask, what's the theory of the case? You know, so often it kind of blunders around without really focusing on what it's on. And that's where the preparation comes in. So you should insist that your lawyer give you the time to work with him or her and prepare the mediation, much as your lawyer probably would not say, I'll meet you at the courthouse and we'll have a trial without talking to you. The same should happen with mediation.
Yeah, no, and I think that's critical. And I say this all the time. And I think with mixed response, I think a lot of people still, they'll either meet with their lawyer the morning of the mediation or maybe a couple of days before and have a quick debrief or not debrief, a quick prep meeting. But it's really just, they're both on the same side and they're acting, the lawyer's acting as cheerleader and saying, yeah, I agree, yeah, I agree. And the other side just completely out to lunch and their brief makes no sense and we're going to go in there and they don't have that, discussion of reality,
Mm-hmm.
of the strength of the case, a theory of the case, as you said, potential risks. So I always encourage, parties, if they're not getting that from their lawyer, to insist on it, to insist on having a frank conversation about the case, potential outcomes, potential costs. Now, you may have the strongest possible case, but if it's going to cost you $100,000 to litigate and you're only saving $50,000 in liability, then it doesn't make any sense. So they should have that discussion. Um, and the other point I was going to make is that, and feel free to disagree with me or let me know what you think. I often have clients say to me, well, before we go to mediation, we should set our bottom line. We should make sure that we're all clear we're not going to pay more than X or accept less than X. And I very strongly discourage that because, in my view, you're missing one of the other benefits of mediation that we haven't talked about yet, which is in almost every case, it's the first time that a neutral third party is going to be reviewing your case and providing you with their view of the case. So we may think that the case is very strong, but the media may look at it and say, I think you've got some real weakness here, and this evidence is not as compelling as you think it is.
Yeah, I think, and kind of tied into that is, and again goes back to preparation. You don't want the client, or nor should the client want to find out there are actually weaknesses in their case and strengths in the other side's case in the mediation, where they're often taken aback. And that comes back to something very fundamental, which is, lawyers' duty to communicate with their clients, because the client remembers the first meeting where they were told it was a good case. If it's not updated, then in mediation, suddenly the mediator says, well, X, and they're not expecting that. And that's very bad because it puts both the client and counsel in a bad place. And it then becomes more about, maintaining your position than actually moving towards a settlement. So I think you're
Mhm.
right. And the costs are phenomenal. I mean, I was speaking with a lawyer recently who told me on $1 million action in Toronto, which isn't a big action anymore, you're looking at, 300,000 apiece in costs. So we're dealing with, even in relatively common type of cases, we're dealing with lots of costs. And in smaller cases where there's less money to move around, the costs, not including your time and effort and strain and everything else, are phenomenally important. So I think there's an analysis that needs to be done that isn't always done prior to going to the mediation.
Yeah, I completely agree. And just on that point, and before we move on to talk about arbitration, I mean, one of the things, and it's a bit of a balancing act, because one of my frustrations as a mediator is when the parties, and it's typically the employer, show up at mediation, and when I ask them for the evidence of a point, maybe they're asserting just cause, for example, and they're saying the employee engaged in misconduct. When I ask for the evidence, they say, "Oh, if we don't settle today, then we'll get that." And I think you've now just missed a really big opportunity to settle this or settle it for in an advantageous way. But they're often when I push them as to why they wouldn't have provided that now, the answer is a cost. We didn't want to spend all the time and money if we could settle, but if we can't settle them, we'll do it. So there's a bit of a balancing act there, but just curious as to how you would what you would say to counsel in that situation.
Well, I think it also comes back to the model that's used. In the traditional litigation model, there's a flurry of activity at the beginning, and then it kind of drifts along and eventually wends its way towards trial. And before that, there's all kinds of preparation. I think we have to move people, whether in almost any kind of case, but I think we have to move people more towards realization that you should front end load your case. You should pull together the information and evidence and prepare it, and not just do what you did in the last case. Or if you're, an HR representative has been in many mediations, like don't necessarily think because the paper looks the same, it's going to be the same kind of case. And that's where mediation advocacy comes in. And part of that are the mediation briefs, which I'm afraid is another area where we could probably talk for hours about how they could be perhaps improved and by doing that, help your client. I mean, all this is about helping your client get the outcome your client would like, or something close to it, in my
Absolutely.
view.
And that's, like I said, it's a pet peeve of mine that people aren't producing the evidence up front and put it right up front in the brief. And especially now that we're using electronic briefs, you can embed a video right into it. And I've used this example in presentations I've done. If you're comparing a paragraph which says, the plaintiff struck his colleague while at work, that sends a bit of a message. It's far more compelling when right below that you have the video of the person striking his colleague in the workplace. So, as you said, front end load by getting all the information up front and then put it in your brief. Because mediation is advocacy, and a lot of people don't think of it that way. And even if you settle, that's not necessarily a win. But if you
No,
settled for a good result for your client, then that's a win.
yeah, I think the advocacy issue is a really important one. I mean, advocacy is really about persuasion. And we're still getting many years down the road, I think, a fundamental misunderstanding of who you're persuading in mediation. I mean, you're trying to talk to the other party and you're not trying to actually persuade the mediator, yet we still get that. And I think that just shows a kind of disconnect in the process. And I think in many ways that's our fault as mediators for not insisting on higher quality materials and preparation. And part of that is, well, we don't upset perhaps people because then we might get work out of it. But the reality is that if mediators were a bit more demanding, I think the quality of mediation would shoot up. And I think clients would be better served by that kind of approach. But we haven't done that.
No, I think it's a great point, as well as your reason why we probably don't do that. So your point about who you're trying to persuade is probably a good segue to talk about arbitration, because I'm also mindful of the time, which, as I said, flies by. So as opposed to mediation, quickly, I guess as quickly as we can, what is arbitration?
Well, I mean, arbitration again is generally considered an alternative dispute resolution process, but unlike mediation, it's within the legal framework, the Arbitration Act. And in arbitration, you hire the arbitrator to make the decision based on evidence. The difference between litigation is it is not bound by the rules of civil procedure which govern a lawsuit. So arbitration can be custom tailored to the dispute in terms of, how are you going to present it? You get to choose your arbitrator who will be a decision maker. And therefore you can go find somebody who's an expert in it. I mean, we have a really great judicial system in Ontario, but that doesn't mean that every judge knows everything. And so you can pick a specialist as your arbitrator. And you also get to customize it to make it very efficient, while at the same time making sure that, natural justice, the right to be heard and to present your case, all those are protected. But the disadvantage of litigation is it is essentially hidebound by the rules and people default to them. And even in arbitration, it is essentially the kiss of death to arbitration to read in the rules of civil procedure. It is a process that works. if you again front end load it and design it to the dispute. But you're not in charge anymore if you're the client. The arbitrator gets to make the decision, and you pay for the arbitrator to make the decision as well.
Yeah, there's a lot there, and I don't want to digress too far, but one of the key points I think you're making is, if you're going to really use arbitration effectively, don't just turn it into a civil litigation. Customize it, and especially in my world, where we're talking about employment disputes, you may have what we'll usually call a simple notice case. It's clear it's a termination. The only issue is how much severance is this person entitled to, and there is not much dispute regarding the facts. Or you may have a case where there are extensive factual issues regarding just cause, misconduct, mitigation, harassment, whatever the case may be. And those two cases could have very different procedures, which get them to the eventual hearing. But when you default to the rules of civil procedure, it's essentially a one size fits all model, which is you're losing one of the benefits.
Well,
Uh, Go ahead.
certainly you're losing a huge benefit. The other thing is, again, as we're talking about mediation, I mean, arbitration can be either imposed on you through a contract or you can choose it. And I think there's a big difference. There may be cases where, even though arbitration looks like a good process, that you might be better off in the litigation process. But in most, you won't. Arbitration will work well because you have such a variety of approaches to introducing evidence, to the hearing itself. I mean, as we know, the Arbitration Act doesn't even talk about a hearing really. So you could do, for example, the one you gave as a relatively straightforward analysis of what reasonable notice would be. You could do that in writing. You really can be skilled. What that means, though, of course, is that it really is important that counsel or the parties, and I think arbitration, it's one of those areas where self-represented parties can get themselves in real trouble. But arbitration, at the beginning, the lawyers have to be prepared to be collaborative in designing the process, even though it is an adversarial system. And that's the key.
Yeah, having the right process is great. Now, the point you made earlier, I think, really applies here, which is people do what they're used to or what they're accustomed to. And in the world of employment law, we are not used to arbitration. In labor law, of course, it's very different.
Mhm.
But I've been trying to bang the drum and get people arbitrating employment disputes for years now, and with minimal take up. And often the response I get is, well, we just didn't even really think about it. We just filed our claim in court. But one of the objections I get gets back to a point you made a moment ago, which is you pay your arbitrator. Whereas when you go to court, I'll put this in air quotes, it's free. So how do you justify the fact that you got to pay an arbitrator, and why is it still worthwhile?
Well, we'll start with one of the, I think, really important points, which is you can hire an expert as your arbitrator. Now, I don't think expertise is all that matters. I think your arbitrator needs to have case management skills, needs to be able to run the arbitration. Um, but why you would hire one over court? Well, first of all, in court, you're stuck in a system that was effectively designed in 1880. The Ontario Judicature Act of the 1880s is essentially replicated in today's world. Then you throw on top of that an underfunded court system where under normal circumstances you're looking 2 or 3 years to get to court, and now in post-COVID you might be looking 5 years, and the costs are mounting. Your lost opportunity costs, your ability to move on, and you don't have any input into how you can design an effective process for your particular dispute. Now, to be fair, most lawyers do not understand arbitration because they didn't learn it in law school. Well, most lawyers didn't learn negotiation in law school either, never mind arbitration. And it's only those who perhaps went through labor arbitration courses at law school or who have statutory arbitration, such as in the Condominium Act. It's only those lawyers who really kind of get it. To everyone else, they think arbitration, they think massively huge international cases costing gazillions of dollars. And we lose the opportunity to take arbitration into the mainstream where it can be highly effective. Cases sit for years. They could be arbitrated and over. And, it's not going to go to trial anyway.
That's a critical point that I always try to drive home. It's almost inevitable it's going to settle in one way or another without a trial. So what's the best way to do this to get the best possible result? Which I guess brings us to the third form of alternative or advanced or appropriate dispute resolution, which is MedArb, which I know you like myself are a strong proponent of. So what is MedArb and why should people be using it more?
Okay. So until quite recently, when people thought of MedArb, they thought of it as a mishmash of bits of mediation and bits of arbitration, when in fact it's not. It's an integrated process. And we see that reflected in the fact that the ADR Institute of Canada, a number of years ago, came out with rules that set out a pretty good process. And essentially, it is divided into phases. And funnily enough, when people were looking at it as being mediation, arbitration, they really, those two stages and a third one making a decision just didn't look good. But if you actually take it into being a multi-stage model, going from designing it, the agreement, mediation phase, transition, arbitration, and writing the award, you can see how it is an integrated process. What I like about it is that it can be designed to meet what clients would like. It is a submission to arbitration, and so there should be a written agreement. Um, People sometimes balk at the idea of bringing the processes together, but I'm just wondering why that's any different than doing mediation and going to court. You're ending up in the same kind of situation. Much like arbitration, it is a self-selecting process, and most people haven't quite got their heads around it. It's used a lot in family law, labor law. It's now being used, and it's used in condominium law. It's now being used a fair amount in employment and estates and general corporate commercial because it just makes sense. It really can be a very fair and cost-effective process. And I mean, we can talk about the elephant in the room of, oh, how can you be the mediator and the arbitrator
Mhm.
quite a bit. And that's thrown up in almost every situation where you speak about it or suggest it. But and I wish this was my kind of line, but it's actually from Stephen Morrison, who's a well-known practitioner in Toronto, which is that mediation is based on information. Arbitration is based on evidence. As long as you keep that in mind, one person can be very successful as mediator and arbitrator. And the case law supports that. Lots of it from family law on how not to do a MedArb, but they still tell you what you should and shouldn't do. And it supports the idea that as long as the mediator arbitrator, if one person is doing it, as long as their mind is open to being persuaded, it's not much different than any other adjudicative process. And it is a far, far better process for many types of disputes. One which I have been interested in for a long time, and it's only in the last couple of years I've really seen much uptake in it. But I think we're going to see more of it as people understand it in a
Yeah, I'm
different way.
hoping so. And I love that line, which I think addresses that common concern of how can the same person mediate and arbitrate. And the other point I've often made when I get that objection is that you get to choose who the person is. And if you don't have the confidence in them, then you shouldn't be engaging them. You should engage someone that you believe will be able to separate, as you put it, or Steve Morrison put it, separate the information from the evidence and reach a decision. And again, people love the idea that they know one way or the other, whether it's through some sort of settlement or some sort of judgment, this case will be over. And we're now entering, the final phase. People love that. So I think that's really important. One of the, I'll get to this, and then again, am mindful that we're already at 1 o'clock, so we should wrap things up. But one of the objections I have had where we go through the process, and typically in the mediation phase, I will say you should be very comfortable being open with your mediator and tell them what happened, and don't worry that's going to come back to bite you, so to speak. Now all of a sudden we're at med where this mediator could become the judge. And what do you do when a party says, "Oh, well, I don't want to tell him or her that because that might hurt me if we go to arbitration"? Um, how do you address that concern?
I think it's a very valid concern, but I think it's overblown. First of all, I'm not so sure. I think parties in a dispute in mediation tell you everything anyway. And secondly, you can kind of guide them through the process. They should work with their lawyer whether they're going to disclose things. You can take everything in caucus as being confidential or they're in individual meetings. You're going to go through a transition stage where you'll set out what you're going to do in the next arbitration phase. Um, but you can also do things if you're really uneasy about it. You could have an opt-in, opt-out, and opt-out mechanism where I'm not comfortable with something you said. Let's get another arbitrator, and you can either have a standby arbitrator, or you could have chosen who the standby arbitrator would be, or you could give the mediator in this a list of names and have them given the power to choose. I find that people will either trust you by the time the mediation goes, in which case they'll go ahead. And if they don't trust you, again, this is not my line, but it does come from Daniel Urbis, who's now a justice of the Superior Court in Quebec, but a well-known arbitrator. Arbitrators have a duty. The arbitrator's duty is to produce an enforceable award. We all agree with that. But the second part of it is not to start another dispute over the award. And so if somebody isn't happy with you at the end of the mediation, your clients, both parties, the lawyers, they all probably deserve to have you at least offer, shall I pull out of it? Because you're still locked in the MedArb process and people still have an end in sight. When I
Mhm.
took the first time I took a course years ago in MedArb in BC, one of the people in the course called it mediation with teeth, which I thought a little bit inelegant, but actually gets to the point. It's a
I
good
like that.
process.
Yeah. Oh, there is one model that I've heard of, and I admit I've never actually been party to it, which addresses this concern of the fact that the arbitrator will know things that they quote unquote shouldn't know by reversing the process. In other words, having the arbitration take place first. And it seems appealing in some ways. In my understanding, and you can correct me if I've got it wrong in any way, is that you go through the full arbitration hearing and your arbitrator reaches their decision and will often write it down and put it in a sealed envelope. And then you go to mediation. And the premise of the mediation is that if you don't settle, if we don't settle by 5 o'clock today, I'm going to open this envelope. And now everyone is going to be bound by that decision, which to me can be really powerful because normally at mediation, we say, if you don't settle today, well, at some point, some judge is going to render a decision, but that could be 2 years from now. Whereas now we're looking at it, it's going to be in a few hours. So to me, that can be very powerful in encouraging the parties to settle. It can also alleviate that concern about the arbitrator knowing things when they are arbitrating, because they will not know those things until later. Uh, but one downside I see, of course, is you're incurring all the costs of arbitrating, which now might make it harder to settle. But I was curious to get your quick thoughts on that process.
In theory, it's brilliant. I mean, it really takes away everything. In reality, if we want to use MedArb in your average case, then we have to find some way around people's fears of being the mediator and arbitrator. I mean, there are other processes, MedArb, which is used a fair amount in Asia, and in a big case, perhaps this makes a lot of sense because you can be pretty sure that by the time you get through the arbitration, people will be very encouraged to settle it, and that's really good. The other thing is that um, we have to remember that one of the main points of alternative dispute resolution is, informed consent and what the client is buying into. And so you can explain these different processes and the client can make the final decision. But my concern was just the one you brought up is it's very expensive to do it that way. So I think we'll have to, defer to having that come back in at a later date.
Yeah, I think especially in my world of employment law disputes, most of them just don't have the value to justify that. But it's a neat alternative. Anyways, we'll wind things up there. So that's a wrap for season 6, episode 12 of Fireway. So first of all, thank you to everyone for tuning in. Colm, thank you so much again for joining me for the last episode of season 6. I really appreciate it, and great to have you back at some point in the future. Just a reminder to everyone, past episodes can be found on YouTube and our website and archived on Facebook. Like our page or please subscribe to our channel. You'll get notifications when episodes are live. Very excited that our next episode is going to be on February 20th. It's going to be episode one of season seven. We're going to be freshening things up a little bit, so a bit of a different look and feel. So I'm excited to see how that comes into play and what it looks like. So February 20th will be first episode of season seven. Looking forward to it, and we'll let everyone know about the topic and guests. And just a reminder at Rudner Law, we want everyone to treat their employment relationships as legal relationships and make informed decisions. So follow us on all of our social media and subscribe to our newsletter. But as we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So feel free to reach out to us. Thank you again to Rob, Rebecca, and Mark for helping put the show together. See you next time.
Thank you.